2019 Family Test 5. Number 1, 1013. In determining whether or not the family court has jurisdiction in a child protective proceeding, which, if any, of the following are true? And this was select all correct answers question. A, age of the child at the time of the alleged abuse is controlling. And we know that's false because it's when the petition is filed in Article 10. B, the child need not be currently in the care or custody of the respondents. And that's true, so we can put a little check next to B. C, the family court has jurisdiction over the proceeding, notwithstanding that a criminal court also has or may be exercising jurisdiction over the facts alleged in the petition. And that's true. D, the petition must allege the child is a child under the age of 21, and that is false because it's under 18, so 0 to 17. Question 2, this is an appeals question. In a proceeding pursuant to Article 10, where a family court issues an order returning a child to a respondent previously remanded or placed in the custody of someone other than the respondent, such order shall be stayed until 5 p.m. of the next business day, unless such stay is waived by all parties, and they can waive it on the record in family court or they can waive it in writing. So that's one of those ones where you don't even need to look at the choices. You just got to know in Article 10, previously remanded child getting returned, it's automatic stay until 5 p.m. of the next business day. Number 3, there's a correction on this one, just the section. It's actually 1121 of the Family Court Act and not 1120, where the appellant in a family court matter under appeal is seeking relief to appeal as a poor person pursuant to CPLR Article 11. The transcript of the proceeding appealed from shall be requested within 10 days of the order determining the motion to appeal as a poor person. So this is talking about the transcript must be requested within 10 days of when they're allowed to appeal as a poor person. So there's an order issued, poor person status granted, then they have 10 days after that to request the transcript from the stenographer or the court reporter. Okay, number 4, this is another appeals question, FCA 1112. Select all true statements regarding family court appeals from orders issued in child protective proceedings. So in Article 10 cases. And it says, A, an appeal may be taken as a matter of right from an intermediate, which is also an interlocutory order, or a final order in any case involving abuse or neglect. And that is true. So any case involving abuse or neglect, you have an automatic right to appeal even from a temporary or non-final order. B, pending the determination of such appeal, such order shall be stayed where the effect of such order would be to discharge the child, but only if the appellate court or the family court finds that such a stay is necessary to avoid imminent risk to the child's life or health. And that is true. So this one uses the word discharge the child and then imminent risk to life or health. So discharge, imminent risk to life or health, you need that. The other one, it says previously placed or remanded child, automatic stay till 5 p.m. next business day and return to the respondents. So that one with the 5 business day is returning the child to the respondents. And this one, it says discharge of the child and the imminent risk to the life or health. So that is true. C, a preference in the hearing of an appeal in a child protective proceeding pursuant to 5521 shall be afforded without the necessity of a motion. That is true. So typically in the CPLR, you have to make a motion for a preference, and then the motion can be opposed by the other side. But in Family Court Act Articles 3, 7, 10, 10A, Parts 1 and 2 of Article 6, there's an automatic preference. So again, maybe take a look at that. Off the top of my head, I know it's 3, 7, Parts 1 and 2 of Article 6, and 10 or 10A. Automatic preference. So the 2 with the kids, which is PINS and JD, that's 3 and 7, Parts 1 and 2 of Article 6, and then Article 10. No motion is necessary. They're granted an automatic preference in the hearing of the appeal. D, an appeal from an intermediate order in a case involving neglect may only be taken with permission of the family court or the appellate division, and that is false because in Article 10, abuse or neglect case, you can appeal an intermediate order as of right. So the answer was A, B, and C. Question 5, the family court has, and this is one that you shouldn't even have to look at the choices, It's C, exclusive original jurisdiction over abuse and neglect proceedings. 6, 1046, in dispositional hearing and in all other hearings under Article 10, except for a fact-finding hearing, only material and relevant evidence may be admitted. So when you're hearing competent material relevant, that type of evidence, competent evidence is not hearsay. So in a fact-finding hearing, there's no hearsay allowed. But in dispositional hearing and all other hearings allowed, the evidence only has to be material and relevant. It does not have to be competent, which typically just means hearsay is permitted at every hearing except a fact-finding. 7, a fact-finding hearing in a child's protective proceeding is a hearing to determine whether the child is an abused or neglected child. None of those other things. 8, 1046 sub B, whenever a determination of severe or repeated abuse is based upon clear and convincing evidence, the fact-finding order shall state that such determination is based upon clear and convincing proof evidence, whatever. 9, 1046, in a fact-finding hearing, only C, competent material and relevant evidence may be admitted. So no hearsay in Article 10 fact-finding. 1038. In a proceeding under Article 10 of the Family Court Act, a hospital having records relating to abuse or neglect are subject to a subpoena ducis tecum. Who may issue the subpoena ducis tecum and serve it on the hospital? And this one, it's a little weird because it's a party to the proceeding is included in this. So the answer was D, the family court, the court counsel, the district attorney, the child's attorney, the county attorney, and or a party to the proceeding. The reason this is strange is because normally a party to a proceeding cannot issue a subpoena or a subpoena ducis tecum. If you look at the CPLR, it talks about who can issue a subpoena, and it's a clerk, an attorney for a party, an arbitrator, a referee, attorney general. It's all attorneys, judges, clerks, whatever. Not a party to the proceeding. But in Article 10, a party to the proceeding can do it.